Good. How many people are here? Good morning, everyone. And we are just waiting for more subscribers to join us, and we will start this event in a few moments. Four? Not too many. Well, hello and good morning to you all. Thank you for joining us on this session of spousal refusal applications. We will begin by showing you, sharing our screen with you and giving you an introduction of how we will be proceeding. There will be a Q&A at the end of this presentation, so feel free to ask some questions, and hopefully we can get to the questions for all of those that are currently present attending the webinar. So let's begin. I think we jumped a few slides, so we're going to try to track back a little bit, and always having technical issues. It's never a perfect, when you're doing things live, it's never perfect. So bear with us, please. Okay, so again, welcome. We are North Vista Immigration Consultants, and we will proceed to the next slide. This is a short video, so please be patient. It just introduces North Vista Immigration and what we do. Well, I hope you've enjoyed that short introduction of North Vista. My name is Alex Romano, and I'm an RCIC, and we'll be presenting today on why spousal applications are either refused or delayed. As most of you know, there's been a recent announcement by the Minister of Immigration, Mr. Marco Mendocino, on the efforts of the immigration sector to expedite and accelerate spousal applications. This is good news, but this does not prevail or does not prevent applications from being refused or even delayed. And we will cover some of those topics today. Um, so there are basically two types of applicants done from either inland or outland, outside of Canada. So if you have a family member who you've been married with, and can you, yeah. So if you are planning to sponsor a member of your family that is currently living outside of Canada, there are several conditions that have to be met. And normally, this type of application process deals with people who do not have a visa to come to Canada immediately. So the application is done from outside Canada. It goes through a process where the Canadian consulate reviews the application and even holds interviews. In this process, people who are going through this process can actually appeal the process if the application is refused. And normally it's sponsoring a conjugal partner or dependent child who living outside of Canada. So this is a different approach. It's a different application process, and it's normally done from outside of Canada. If your partner is currently living with you uh, or is interested in an open work permit or has even a valid immigration status in Canada, the application can be done from inside Canada. Allows individuals a lot more flexibility to remain in Canada and actually apply for a work permit while their application is being processed. Uh, and so we will look at the effects of someone who is applying from inside Canada and then decides to leave Canada. There are several factors that one must take into consideration. You need to have a valid visa to return to Canada. And if your application can be denied or is denied, a new overseas application would be required. So if in this case, okay, make sure that if you're applying from within Canada, you intend to stay here. And if you do have valid visa to return, you can take an opportunity to go back to your country temporarily, but you have to come back uh, if you want the application to be continued, its processing within Canada. If you're not present in Canada while your application is being processed in Canada, you may be obligated to, you may create a refusal and then obligated to refile a new application from overseas. In most cases, the suspension of an application process is caused by a number of factors. One of those factors is your citizenship or the individual who is actually sponsoring you, whether you are a citizen or a PR, a permanent resident, your citizenship is under a contest or is currently being revoked. And the point is that if you're currently under a removal order, so you've gone through a stage of process with CBSA, and they have issued a deportation order or a removal order, and you have filed subsequent to that, you have filed for an application for spousal, there's a good chance that this could be revoked and refused. Um, if you fail to respect your residency requirements as a PR, obviously your application can easily be denied. Uh, Other factors include the inadmissibility because of security and human rights violation. And the last, most serious, is criminality or serious criminality of either the sponsor or the applicant. This will create an automatic refusal, unless, of course, there are other measures that where you have served the sentence and there's been a pardon that's been granted, and you can proceed at that point. But normally, these sentences that are punishable by a maximum of 10 years would definitely have an impact on your spousal application. So let's talk a little bit about the checklist and the forms. I want to emphasize here that there are numerous forms and numerous procedures that go through an application process. And I'm going to cover some of these just to emphasize to you that the application process can become somewhat overwhelming, and there's a lot of detail that must be given attention to. So, for someone who is going through this for the first time, it could take months in terms of going through the application, filling the application, and then documenting your application to submit to the immigration office. So some of the first form, there is a checklist to be returned with the application, IMM 5533. There is a sponsorship agreement, an undertaking, IMM 1344. Financial evaluation is another form. Then you have to determine the class of applications. As we discussed earlier, their class depends on whether you're sponsoring outside of Canada or inside of Canada. There is the generic application for applicants, IMM 0008. Then, of course, review very specific country requirements. Some countries require to submit more documents and more evidence than some others. For instance, I understand that the Philippines has certain requirements, additional requirements to submit, where U.S. has maybe less requirements. Um, then, of course, the last or the seventh item here is additional family information. It's IMM 5406. We'll continue on the checklist. It's still, there's still a few more applications that must be actually submitted. So Schedule A is a background declaration, which is IMM 5669. The relationship information and sponsorship application or evaluation, IMM 5532. This determines how you came together, what formed your relationship, and the government always wants to see that even though there's a legal marriage, that there's also genuineness in your relationship. And they do evaluate this very thoroughly. Of course, if you're using a lawyer or a licensed immigration consultant, you need to have IMM 5476, which is use of representative. And you also have to sign off an authority to release personal information if you are designated an individual. Normally, that individual that is being designated could be someone who can bear witness to your application, and that would be IMM 5476. This is not often used, but it can be used if you're wanting to have that person be privileged to receiving information regarding your application. And then, of course, there are supporting documents for sponsors, their status in Canada, their previous relationship. Uh, the complications of an application usually arise if your sponsor was previously married, and there are documents to support the fact that he is no longer married, that he has a valid divorce decree, and that has to be presented in your documents. Of course, there's an employment and source of income and other identity documents to support the identity of a sponsor and his undertaking. The checklist again continues with documents for sponsored family class members, information about minor children, and this is an important issue because if the application does not include an accompanying parent, and the accompanying parent will remain in his country of residence, and there was, even if there was a divorce and custody was given to one of the parents, there is a form that needs to be filled out for the non-accompanying parent. He has to give authorization for the application to proceed. There are police certificates from countries of resident and citizenship. Of course, photos, medical examination, proof of relationship, and this is a very important sector. You have to establish a timeline of how you met, what happened before you were married, and so on and so forth to establish that the actual application, when you're presenting it to IRCC, has genuineness. And finally, there are signature pages that have to be concluded in submitting your applications. So there are immigration laws and regulations that support all of these forms and the application process. We are obviously bound by the immigration laws of Canada, which is they're spelled out in this book. They cover all aspects of immigration law and regulations for other areas other than spousalship applications. But the specific applications that are used within the sponsorship is Part 7, Division 1 and Part 7, Division 2, with all these regulations down below. We will be sharing this presentation with the people who are present, so we will obviously make it available for you for your notes. And we're down here to, I am presenting to you a case study, and I wanted to share this with you because not every case is straightforward. So let's just read this through and see if we can make sense of it, and you may ask me questions related to this case. So Jane and Albert, they decided to be legally married in Canada. Jane is a Canadian citizen, and Albert obtained a work permit while he was married to another foreign national. They divorced in 2016 with this foreign national, and Albert decided to apply as a refugee in 2017 as he was from Iran. And at that time, there were issues of protection of people who were outside of Iran who did not want to return to Iran because they may have been targeted for persecution. But he decided to eventually withdraw his application as a refugee in 2018 while on a valid work permit. So subsequent to that, he met Jane in January of 2019, and they were living together since. They were recently married. Albert was requested by CBSA to leave Canada in 2019. Both of them were previously married and obtained a legal divorce decree. My question to you, people who are listening, if Jane sponsored Albert in an in Canada family member, would the case be accepted or rejected? That's a question, and we can always return back to it. Either you'll have questions or you give me some answers, and I will share with you what are the possible outcomes for this case. In summarization and conclusion, I want to go through maybe 5 points that should be taken into consideration before an application, before considering either getting advice from a lawyer or from an immigration consultant, or even attempting to do this yourself. There are various degrees of complexities, and each applicant brings a new dimension regulated by IRCC laws and regulations. So one must understand its own case in order to look at the laws and regulations that apply to that case. A non-completed application or misleading information can delay processing or even bar you from sponsorship for up to 5 years. So if you have provided misleading information, you could be barred from any sponsorship for up to 5 years. Marriages of conveniences can easily be detected by an experienced immigration officer. So it's obviously that these marriages are constantly under scrutiny, and in the past, historically, we've heard in the news of cases where these marriages of conveniences resulted in deportation of the members, or even cancellation or denial of their application. Appeals can only be made for outside Canada applicants with a greater cost if there's an appeal process. So if you're applying from inside Canada, you obviously do not have the opportunity to appeal, but you can reapply given new evidence. If you're applying from outside Canada and you are asked for an interview at the Canadian consulate of that country, in that country, you are denied, you can file for an appeal, and the appeal can be heard, but it is much more costly to go through an appeal process. And finally, sponsors may face additional bars due to bankruptcy, debt abandonment, and other factors, criminality, that are obviously major drawbacks in sponsoring a spouse from for becoming a permanent resident. So, in principle, if you are going through this process, trust an experienced lawyer or licensed immigration consultant. They they are bound by laws. They understand all of the complexities and can properly advise you from the start as what you could face as a sponsor or even as an applicant. So we have some details here. You can contact us on Facebook or on YouTube, Twitter, and Instagram. So again, we'd like to thank you for attending this webinar and live session. We are going to be open for Q&A questions. Take a few moments. So I guess if there are no questions, we don't seem to be getting any individuals who are asking questions. So we will obviously stop sharing the screen and we will end the session. I hope that the information provided here was useful to you. If you do have any questions, you can always email us um, at North Vista Immigration. We will try to get you, you can call us or at 647-660-5758 or email us at info@North Vista Immigration with your questions, and we would be happy to get back to you with some answers. Thanks again, and thank you for joining us on this live session.